The clock ran out. The case was dead. Then lawmakers did something unprecedented. They turned back time itself. And suddenly, criminals who thought they'd escaped forever found themselves facing courtrooms again. For over a century, American law operated on one absolute principle. Miss the deadline, lose your case. Forever. Statutes of limitations were considered sacred, untouchable boundaries protecting defendants from stale evidence and fading memories. But here's what nobody expected. Starting in the early 2000s, state legislatures began doing something that legal scholars said was impossible. They started opening windows. Temporary periods where victims could file lawsuits for crimes committed decades ago, even when the original deadline had long passed. California did it. New York did it. Now over 30 states have either passed or are considering these revival window laws. But here's the question that will determine whether justice actually gets served. Are these laws even constitutional? And what happens when the institutions being sued fight back with everything they have? Let me put this in perspective. Imagine you committed a crime in 1990. The statute of limitations was 5 years. By 1995, you were legally untouchable. You could confess on national television and no one could sue you. That was the deal. That was the law. Then in 2019, New York passes the Child Victims Act. Suddenly, there's a one-year window where anyone can file a lawsuit regardless of when the original crime occurred. Cases from the 1970s came flooding into courtrooms. Perpetrators who'd lived decades thinking they'd escaped. They were wrong. Over 10,000 lawsuits were filed in that single year. The Boy Scouts of America declared bankruptcy. Major religious institutions faced hundreds of millions in potential liability. If this is making you realize how massive this legal shift is, drop a like so I know to keep digging deeper. But here's where it gets complicated. And I need you to pay attention because this determines everything. The Constitution has something called the Due Process Clause. It protects people from laws that retroactively change the legal consequences of their past actions. Defense attorneys immediately challenged these revival windows. Their argument? You can't change the rules of the game after it's already been played. A defendant had a vested right to that expired deadline. Taking it away violates fundamental fairness. For criminal cases, they're mostly right. The Supreme Court has been clear. You cannot criminally prosecute someone after the statute of limitations expires. That deadline is locked. But civil cases? That's where the loophole exists. And it's a loophole big enough to drive decades of justice through. The Supreme Court addressed this exact issue. In 2003, they ruled in Stogner v. California. A man was criminally charged for crimes decades old after California extended its statute of limitations. The court said no. Criminal prosecution after the deadline violates the ex post facto clause. Case dismissed. But here's the critical distinction. That ruling only applied to criminal cases. Civil lawsuits operate under different rules. States have much more flexibility to revive civil claims. Why? Because civil cases don't threaten someone's liberty. They threaten their wallet. And the courts have consistently held that financial liability doesn't receive the same constitutional protection as physical freedom. This means a perpetrator can walk free from criminal court while simultaneously being dragged into civil court for the same exact conduct. Two different systems. Two different outcomes. But that's not even the most shocking part. What nobody tells you is who's fighting hardest against these revival windows. It's not the individual perpetrators. It's massive institutions with deep pockets and armies of lawyers. Insurance companies. School districts. Religious organizations. They've spent millions lobbying against revival. Window legislation. Why? Because they're the ones who actually pay when these lawsuits succeed. And their strategy? Delay. Challenge every constitutional question. Appeal every ruling. Make the process so expensive and exhausting that victims simply give up. In Pennsylvania, the Catholic Church successfully blocked revival window legislation for over a decade using exactly these tactics. If you want to see how this fight ends, make sure you're subscribed because we're just getting to the real battle. But here's where it gets interesting. The victims started fighting back with a weapon no one expected. Ballot initiatives. When state legislatures wouldn't act, victims took their case directly to voters. In New York, survivors organized a grassroots campaign that generated over 50,000 calls to lawmakers in a single week. They showed up at every public hearing. They shared their stories on the record. And they won. The Child Victims Act passed with overwhelming bipartisan support. But the institutions didn't surrender. They pivoted to a new strategy. If they couldn't stop the laws from passing, they'd challenge them in court after the fact. Case after case, they argued these revival windows violated due process, equal protection, and fundamental fairness. And in some states, they actually won. Courts in states like Ohio and Pennsylvania struck down certain revival window provisions. The legal battlefield became a patchwork. What works in New York might be unconstitutional in Ohio. What survivors can do in California, they can't do in Texas. And this brings us to the moment everything changed. In 2022, the Pennsylvania Supreme Court made a landmark ruling. They upheld the state's revival window against constitutional challenge. Their reasoning? Victims never actually lost their claims. The original statute of limitations just suspended their ability to file. The revival window simply restored what was always theirs. This legal framework is now being adopted across the country. It sidesteps the constitutional issues by reframing the entire concept. The deadline didn't eliminate your rights. It just put them on pause. And the state can hit unpause whenever it chooses. This single legal theory has opened the floodgates. Cases that were dead for 30, 40, even 50 years are suddenly alive again. And the institutions that thought they'd escaped accountability? They're learning that time doesn't always run out on justice. So where does this leave us today? Right now, in 2025, at least 12 states have active legislation pending to create or extend revival windows. The legal theory that survived Pennsylvania's constitutional challenge is spreading. But so is the opposition. Insurance industry groups have hired top constitutional lawyers to develop new challenges. They're arguing that unlimited liability exposure is fundamentally unfair, that evidence degrades, witnesses die, and justice becomes impossible after decades pass.